Hi, my name's Jonathan Midgley. I'm a chartered patent attorney, and today we're going to talk a little bit about what IP is and try and give you a feel of how you might use that in your sort of business, both from day one and right through to maturity. There's a lot of misunderstanding about what IP is and how that can be used in businesses and the different types of IP. So we'll hopefully sort of clarify some of that, how you can use it, and how you get the most out of it in your sort of normal business activity. We're going to do some question sort of period at the end. So if you have any questions, then please either pop them in the chat if you want, or we can save them till the end. So I'll just do a quick overview of what we're going to talk about, really. We're going to sort of discuss what intellectual property is and the different sort of various types of intellectual property and how they may be sort of utilized in your business. And then we'll talk a little bit about why you might want to protect your IP and what it can do for you, how you go about doing that, and also the time frames for thinking about IP and how to get that protection in place. We then look at sort of things like the costs and the timeframes particularly for registration of IP rights, and then look a little bit at the alternatives if you don't want to, or a registration of IP is not applicable, just some of the other sort of IP features that we can utilize as part of a business. And then we're going to do a sort of a quick case study just to sort of go over the sort of how a new business might sort of develop its product and how it then go about sort of implementing its IP protection as part of that sort of early stage development up to and after the launch of the product. And then finally, we'll have some discussion about the management and use of IP and how the ongoing process of IP utilization is done in a business. So the first question is, what is intellectual property, IP? Intellectual property is a sort of very broad term that covers the sort of general idea of this idea of an intangible thing that has some sort of value, particularly to a business, that it is difficult to sort of quantify. It's not something you can put on a table. And so there are sort of various regimes and legal structures that are in place to try and prevent the copying and utilization of your intellectual property by others. And really, intellectual property breaks down into sort of two groups. You can see here we've got this idea of unregistered rights, which are essentially rights that just happen, they come into existence, and you don't really need to do anything about them. And in some cases, they are sort of defined in law, and there are lots of legal structures around it. So, for example, copyright, which I'll talk about a bit in a minute, is most people have heard of, and it covers all sorts of aspects, but there is a very sort of defined legal structure around those. And design right is similar to copyright. It's sort of another of these rights that happens automatically. You don't need to do anything to register it, but it provides a sort of quite detailed legal protection. But there are lots of other IP rights that you may have inadvertently, and most people, whether they like it or not, have created some kind of IP, some kind of creation, some right that they may have, and it's still important to try and nurture and manage those rights to make sure you get the most out of them without sort of wasting them or allowing them to sort of wither on the vine. So things like confidential information, you may have lots of internal know-how or secrets within your business, the way you manufacture products, the way you market products, all this sort of slightly intangible sort of stuff has considerable value in most businesses, and how you manage those can be quite important to how you succeed. And again, we mentioned recipes there at the bottom. That could be a recipe as in cooking, but also a recipe as in how you make a product. And the techniques that you use to get there. And again, those are things you probably want to keep within your business and stop other people using, because it has quite a lot of value to your business. And then the other side of the equation are these registered rights. And again, people have often heard of things like trademarks and registered designs and patents. These are all rights that you have to formally apply to, usually like a government body, like a patent office, to get those protected. And you go through a process of assessment of some kind, and then at the end of it, you're given a certificate that says you have a patent, a trademark, or a registered design, which you can then use to enforce your rights against other people. And these are obviously quite powerful rights because they allow you to go to court very quickly, get injunctions, and also, potentially get damages and stop people doing things. So that they have a sort of quite a good strength to them compared to some of the other rights, which can be a little bit more difficult to enforce because there's often lots of evidence required to demonstrate ownership and the content of those rights. And there are lots of other little rights that perhaps people haven't heard of. There are things like semiconductor rights that allow you to protect the layout of a semiconductor, things like plant varieties, again, a very niche sort of area, but if you're in the plant breeding business, that can be very important and allows you to register a new variety of plants. So again, there are quite a lot of things that you can utilize that aren't necessarily those that are obvious. So looking at some of those major rights in order, starting with copyright, again, as I say, copyright is an unregistered right. And so you don't necessarily need to do anything to formally get that protection in place, but there are some steps that you might want to take to make sure that you've got the most out of that protection, which I'll come on to a little bit later on. But copyright it protects many kinds of creative activity, and it can be a drawing, it can be an image, a video, some music. It can also cover computer code in sort of written form. And so it's pretty comprehensive in protecting those things. And there are sort of requirements that you need to put in place to ensure that the protection you're entitled to is as robust as it can be. So things like making notes and writing those down and dating documents is very important, because this can be very useful for evidencing when something was created and that you created it later on. In order to qualify for copyright, your work, whether it's written or an image or anything, has to be original. You have to have created it. It can't be just a copy of something else. It's kind of logical. Also, in order to infringe your copyright, somebody must have copied you. As the name suggests, it's a right to stop copying. And so if somebody independently creates something that looks very similar to what you've done, that's not strictly a copyright infringement, and it can sometimes be difficult to prove that they have copied you. And that's why sort of copyright has its sort of limitations. But generally, it's usually quite clear that somebody has copied you, because it's so sort of unreasonable to expect that they would have got it any other way. But there is that requirement that copying has taken place. And again, copyright's sort of limited in some ways, in the sense that it needs to be a fairly close copy, and either an exact replica of what you've done or a fairly substantial copy. So again, if it's a written work, you're looking at sort of a page or two it starts to become substantial work. A few words wouldn't necessarily be considered substantial, and therefore not necessarily an infringement of copyright. One of the nice things about copyright is it lasts for a very long time. You can see there it says life plus 70. So basically, the copyright will extend from 70 years after the death of the creator of the work. So again, any kind of copyright has an enormous longevity and can be quite powerful in a lot of areas, particularly in the creative works, like obviously writing books and writing music. Going on to unregistered design right, this is the sort of the less well-known sort of cousin of copyright, and it works in a similar kind of way. You don't have to take any action, and it comes into existence automatically as soon as you create a piece of work. Unregistered design right, as it suggests, design relates to the design of a product, and it covers the aesthetic aspects of a product usually. It needs to be represented in a design document. So in order to make sure you get that protection, it's important to have a written representation of that particular design. So normally you take a picture, or you've got technical drawings or something like that, and they will act as the sort of guardian, the piece that represents that design creation. And again, like copyright, it's important to make sure you've got good records of when that was created, and ideally date it and sort of make a note of who created it. So there's a good sort of paper chain of who created that document and when. So if there's any discussion about copying, at least you could say, I created it on this specific date, and therefore, your design that you copy, or I allege is copying, was done at a later date. You've got a much stronger case in court to evidence that you were the first creator. yeah, design really relates to the shape and configuration of articles and less about the sort of patterning and materials that it's made of. So it's kind of a relatively simple shape-based thing. So it's very good for things where there is an aesthetic design to it, things like crockery or classic sort of alloy wheels, those kind of products where they have a function, but then there's a lot of design choice to be made, and so you can have that sort of aesthetic aspect to it. Um, these don't last as long as copyright. They're much more of a sort of commercial tool, and essentially they last 10 years from when you first start to sell the product, although there is a cutoff for 15 years from the date of creation. But generally, you're looking at that sort of 10 years from sale as the sort of longevity. So again, quite a long time in a commercial sense. Often creative products will be replaced in that time scale anyway. And the nice thing really with those is you don't really need to do anything other than just sort of make make sure the paperwork's in order. Coming on to the sort of the bigger sort of registered rights, these are a much more sort of serious undertaking because there tends to be more of a cost associated with them, but also they have a much more significant sort of weight to them in terms of their legal activity. So first of these is patents, and probably this is the sort of bigger of all of them in terms of cost, but also in terms of significance to a business, particularly a technical business. So patents relate to the technical concepts and methods that underlie development of products in a commercial environment. Their purpose is to prevent copying of those designs, and it gives you a monopoly over that design for the period of the patent, usually up to 20 years. It can cover a lot of different things around that. It can be actual physical products and the makeup of that product. It can be the processes used in manufacturing that product, or it can also include things like software and computer-related inventions. And there's a lot of misunderstanding around those, whereas copyright can cover the code or that you might have. So if you've got a word processor like Word or something like that, or Outlook, the actual underlying code that sits there to provide that functionality, that's protected by copyright. The concepts and functionality, a bit like the methods that they undertake, can be protected by patents as a technical process. And again, I say there's a lot of misunderstanding around this, but there's a lot of software related and computer invention related patents that are out there already, and that people are making use of. Patents also have this slightly unique feature where you can get a reduced rate of corporation tax using this regime called patent box. And essentially, any products that you sell that are covered by a patent that you own and have developed, you can apply for this patent box regime, and it allows you to pay a much lower 10% corporation tax rate on profits from those products. It's phenomenally complicated. It started very simple when it first launched about 10 or so years ago. It now seems to become sort of more and more work for tax advisors and accountants, but fundamentally that's really what we're talking about, is this reduced corporation tax rate on the profit from products that are protected by a patent. And as I mentioned at the bottom, patents last up to 20 years. I'll mention a bit later on, but you have to pay an annual fee to keep those going, really, to make sure that there's value in that protection being provided by the government in exchange for a sort of license fee for you to continue to have the patent protection in place. So sometimes patents will expire because the owners decided that there's no longer value in continuing to keep it. The next sort of big registered IP is trademarks. And whilst you can have a trademark and it doesn't need to be registered, it's just a mark that's associated with your business, you can register those trademarks. And again, there are a lot of advantages to that registration process that allows you to get much more effective and quicker access to justice. It allows you to get things like injunctions. There's a much lower level of proof. It's much more clear cut that if you have the registered trademark, pretty much the assumption is that you have the rights over that name. And so there's less discussion about whether or not you should be entitled or have ownership of that trademark. Trademarks cover various aspects of the commercial get-up. So it can cover brands for names of products. It can cover the company name. It can cover logos associated with your business, so just images, but also names, just pure text. And then, again, another thing about trademarks is they last indefinitely. There's no end of life to trademarks. You have to renew them usually every 10 years. But other than that, they can go on forever. And we have, trademarks that are now almost 100, 150 years old. I think the first one was registered for Bass, the beer company, in the late 1800s. So again, it's a very important part of your business. And you look at some of those major corporations where really the brand, things like KFC and McDonald's, those sort of brands where the name is really the principal part of their business. And so can become very, very important for a business. Again, there's another right called registered design right. It's a bit sort of similar to the unregistered design right that I mentioned before. It's again directed at, rather than the technical side of things, which a patent would cover, to the aesthetic side of product. So again, if you're in the creative product business, such as crockery or designs or interesting articles from an aesthetic perspective, then registered design right might be something that you'd be interested. And it can cover anything. It could be furniture, really anything in a business sort of ambit that is have some kind of aesthetic value. And it covers principally features of shape and configuration, but it can also cover things like the contours, the textures, and even the materials to an extent. So if the material is made of glass or metal or fabric, you can cover those sort of aspects of things. So it's a little bit broader than unregistered design right, which is really limited to shape and configuration. So it gives you a little bit more scope for really protecting the idea. And when you apply, you just have to provide a set of images showing the product, usually from sort of top, bottom, left, right, and that sort of thing, so somebody can understand what the product looks like. And also you don't have to cover the entirety of the object. You may even cover a small part. So there are lots of patents, registered trade designs around elements of a design. So for example, there are with mirrors for cars rather than an entire car. And even sort of sub features within a single product. You can also apply. Registered design right has this sort of ability to apply for multiple designs in one sort of bundled application, which helps to reduce cost. And so you could, if you've got a range of products that all sort of relate to each other, again going back to sort of say crockery or cutlery, if you have a range of products, you can put those all together in one application, which helps to keep the costs down and lump all those together. So we're going to talk about now a little bit about the sort of why you want to get IP, why you should think about it, how you would go about getting it, and what is the sort of right timing to be thinking about and applying for IP protection. So first of all, why would you think about IP? And as I've sort of said already, IP can form a sort of an important part of the whole sort of business process. And what it does is it allows you to prevent or control access to those creations, those intellectual creations that you might have as part of your business. And that can serve lots of purposes. It gives you a competitive advantage if you've got a way of producing a product that is a little bit better than competitors, and they don't know how to do it, or they can't do it because you've got a patent to stop them using technology that will allow them to implement that. Or if you've got a brand that's of considerable value and somebody's trying to break into that market, they've got to start their own brand. And so they're trying to fight that uphill battle to get that recognition. All these things provide a sort of a protection and a margin, and some margin. Maybe just, you're allowed to charge more because you can do that because you've got a slightly better product, or you've got, features that your competitors can't provide. You've got that technical edge. All those things can be sort of secured and encompassed by IP that allow you to have that sort of commercial advantage over your competitors. IP can also be used in different ways. So there's that protective process that I just sort of talked about, but also if you've got IP and you don't necessarily want to use it in that protective way, you can use it as a source of revenue. You can license it to other people to use. You can sell it as an asset, like any other asset, for someone else to have and own and have that protection that you might have had. And also that can then, to come around and provide, more revenue for then developing further products and so on. IP can also give a company a sort of leverage and sort of power in the market that allows you a stronger negotiating position, both in terms of dealing with competitors, but also if you're looking to sell your business or get funding for your business. those IP rights help to sort of underpin that sort of structure and value to the business. And also things like franchising, most franchising businesses are totally dependent upon IP. If you're setting up a branch of KFC, really all they're giving you is the right to use the name and the logos and the get up that you might have in a restaurant, and maybe some of the sort of technology that's underlying the sort of food preparation process, then that might be covered by patents. So you've got trademarks, you've got patents, and possibly even designs as well in there in terms of the way that the shops are laid out and those kind of things. Those all packaged together in an IP bundle that you can then sort of sell as a franchise operation. And again, finally, there I mentioned the sort of this patent box tax treatment. Again, that can give you some sort of advantage of being able to get a sort of a lower tax regime and therefore a better retention of your profits. One of the sort of important aspects of IP as well here is this is as a sort of asset of the company. I've sort of touched on that already, but when you're particularly at a startup stage, you have this massive sort of potential. You've got done a lot of development. You've got products that are in development and ready to launch. You may have branding that you've created and invested time and effort in marketing, and all these things are sort of a little bit sort of intangible. And if you sort of pull the company apart, you've got to ask, what's left. So you're asking for an investor or a funder or a buyer to come and look at a company. They're going to say, well, how can I sort of ensure that this thing I'm investing in or buying is going to retain its value when we've sort of completed the sale or the fund? Because if people who are within the company drift away, you can suddenly find that there's not a lot left of that sort of asset that was there. So by registering these rights or by securing your copyright and other aspects of your IP, you start to put together a sort of a more tangible bundle of things that can help to sort of underpin your business. So that might aid in improving the valuation because you've got tangible assets that stick with the company, and the point at the end there is the IP can then be sort of tied to the company, and it's not sort of then left as sort of the know-how that's in the brains of the company employees. And again, when you've got know-how that's in employees' brains, of course, if they leave, that can sort of get disseminated and the value get distributed. If it's covered by a patent that's owned by the company, doesn't matter if they go away and tell their new employer all about it. That new company can't utilize that IP because it's protected by a patent that's tied to the original company. So again, this IP bundle often acts to provide a very substantial or realized, tangible way of underpinning the value in a business. So, investors and buyers are sort of reassured that they're actually getting something more tangible than a bunch of sort of thoughts in the minds of potential employees that might move on or go away. So moving on to the sort of how you go about getting the rights, particularly the sort of registered rights, which require sort of much more proactive action compared to the unregistered rights, which generally sort of look after themselves, subject to a few sort of things like I mentioned before with dating and that kind of thing. So patents, starting with patents, the process for a patent is obviously you've got to sort of prepare and put together a disclosure of what your invention is. So the first part of that is to define your invention and describe it in a way that's sufficient for someone to understand how to put the invention into practice. And you then submit that as a document to an intellectual property office, the patent office, who will then sort of start the process of analysing and determining whether the patent should be granted and what scope of protection you might get. It's important to make sure that application is done at an early stage, and we'll talk about that a little bit further on, but the filing patent application is judged against what's in the public domain at the date you file out your application. So if you've disclosed your idea before that filing date, you might find you've shot yourself in the foot because you've put your own idea into the public domain, and you then can't protect that because it's now become public knowledge, and you can't get a patent to cover things that are in the public domain. So it's very important, and again, I'll come back to that in a minute. Once you've applied to the patent office, we start this sort of quite slow, in a lot of cases, process of the patent application. And initially, the patent office will sort of do usually a search for similar technology to give you an idea of what is already out there and to give them a basis for how they will then do their examination process. And depending on which country you're in and what sort of process and steps you want to take, that can be done quite early on, or it can be done quite late on, depending on the way you act. We normally advise clients to get that search done and also the examination stage started as early as possible, so you've got a good idea of what you're likely to get out of this patent application. Patents are published after 18 months in pretty much every country in the world. And this goes back to the whole sort of premise of a patent application being that in exchange for you getting a 20-year monopoly for your patent, you have to give the details of how that invention works so that the public can understand that. The idea being at the end of your 20 years, the world is now sort of enlightened by how your invention works and you've made a contribution to this sort of general background of the technological area. So the Patent Office then will go through this process of examining your application to determine the way you've defined your invention and whether that's sort of sufficiently meritorious of whether a patent should be granted. And they do this search, as I say, this prior art search, looking for existing technology to try and get a feel for what the state of the art is at the moment. And then they'll look to see if your invention, as you've defined it, is sufficiently new and non-obvious compared to that existing technology. So again, the new or novelty aspect of that is really just your invention needs to be different to something that's already out there. The more subjective and perhaps more challenging part is demonstrating that you haven't just taken existing technology and made a very small, insignificant, obvious step forward. And that doesn't have to be particularly earth-shattering. We're not looking for sort of rocket ships and hovercrafts and that kind of stuff. It's just, it needs to be a small advance that wouldn't be an obvious day-to-day sort of modification that would anybody would carry out without really applying too much creative thought to it. And once you've met those requirements, or assuming you haven't met those requirements, the Patent Office will normally come back and say, well, you've defined your invention in such broad terms that it encompasses all sorts of things that exist before, and so it isn't sufficiently new compared to what's gone before. And there'll be a sort of toing and froing, some arguments, with some explanation that you will provide to the examiners, and also maybe a refinement of the way you've defined your invention, and usually to get to a point where the examiner can say, yes, okay, now we've defined it in such terms that it's sufficiently differentiated from the existing technology that we can actually give you a patent for it. And that process will then go through to the issue of your certificate, and you will then become a patent owner. That process typically takes anything from about 2 to 5 years, depending on which country you're in. And also you can control to some extent how quickly that happens. As I said, in the UK, for example, you can ask for the search and examination to be done very early, which can theoretically allow you to get through to that examination allowance stage, often within a year or so. But generally, there are lots of pros and cons to doing it quickly, and sometimes it's better to actually let it drag on a little bit longer, which gives you a degree of uncertainty, but it also gives all your competitors a degree of uncertainty as well. So there are sort of pros and cons to that. So typically, that 2 to 5 years is what most people sort of experience. It can be longer. Again, some offices like the European Patent Office have processes that allow third parties to object to you being given a patent, and so that can make things go on a lot longer. This might sound like you sort of got to wait a long time before your protection starts, but in actual fact, the protection that you get starts pretty much as soon as the public is aware of your patent. So from that 18-month point of publication, people are essentially put on notice, and if they start to infringe the patent after that point, they will be potentially open to damages, and you can go back and retrospectively get damages and compensation and all those sort of things, even though the patent wasn't granted at that time. And you can even put people on notice earlier. So if you filed a patent application today, you could send a copy to your competitor tomorrow, and they will be on notice at that point. So any infringing activity that they carry out after that point, they will potentially be open to damages and obviously risk substantial payments that they might have to make to you in compensation. So moving on again to trademarks here, as I sort of mentioned, a trademark is a mark or an indication of some kind of value to a business, and you normally would start off with the trademark being unregistered, and that those rights are there, whether you like it or not, sort of thing. But you can then go on and register those rights to improve your ability to enforce and deal with those. The registration process for a trademark is kind of similar to a patent. You have to apply to an intellectual property office. They will carry out a basic examination of the application to make sure it meets largely formal requirements. And that will then go through that sort of process and will usually get allowed typically within a sort of 6 months to a 1 year time frame, depending on, again, if there are any issues or not. If it goes through without touching the size, it may be much quicker than that. The fundamental requirements for a trademark are that it needs to be distinguished from existing marks that are already out there, or existing sort of logos or whatever it is it might be dealing with. And it also needs to not be descriptive. So cornflakes is not a very good trademark because essentially it's saying what the product is. And the idea is the government doesn't want to give monopolies over something that is essentially a description of the product. So you need to think of slightly more unusual names for your trademarks to ensure that you don't get issues with that. Having said that, there are lots of trademarks that have been around so long that have developed a sort of a recognition in the public's eyes of that product being particularly associated with a specific company. And that's the general idea. The trademark should be something that when people see it, they go, oh, that belongs to company X, Y, and Z. And there's that unique understanding so that when they buy that product, they have a reassurance that they're buying from a specific source or company. Going back to unregistered trademarks, the challenges are with those, it's harder to enforce because there isn't a sort of an assumption that the trademark belongs to you. So you have to demonstrate that essentially that the person who is using your mark is passing themselves off as being you. So then you've got to try and develop evidence, usually by sort of, speaking to people in the public domain and saying, would you be confused with these two products, thinking that, one that's the competition is sort of related somehow to your product. And so it can be a little bit more challenging, and a greater amount of evidence is required to demonstrate that there is genuinely this idea of that this other company passing themselves off as being related to you. And that makes it much harder to get the process through, and also to get enforcement and injunctions and that kind of thing. Whereas a registered trademark has a much stronger right in the sense that it gives you the ability to just say, I own these rights, and it's very hard for someone to counter that unless they can demonstrate that they were using the mark 20 years before you filed for your registration. And then finally, registered design rights. Again, I mentioned this. The process, again, is quite similar. You put in an application. It goes through a basic examination just really to make sure it meets the formal requirements. And then normally will be allowed, usually within 6 months. The UK sometimes will do it even quicker than that. I've had ones granted within weeks. And again, in other countries, it can be a little bit slower. And once you've got your registration, you can put your little R on it, and that demonstrates that there's a registered right in place. The basic requirements for a registered design, again, a bit similar to patents. It has to be new, it has to be different to any existing design, and it has to have some kind of aesthetic value to it, which it can't be purely functional. So again, to avoid people protecting functional features of a thing, a product, that's not what registered design right is about. So it explicitly doesn't cover functional aspects. It's really just the appearance. And again, the sort of twin sister, as it were, to registered design rights are unregistered design rights, which happens automatically, a bit like copyright. And the main thing there to make sure that those rights are easier to enforce is to keep dated records of those. And so coming on to the sort of when, patents really are the ones you need to think about at the earliest stage because of that thing I mentioned before, which is this need to file the patent application before you disclose the idea. Now, you can keep things confidential. You can talk to suppliers. You can potentially talk to customers. As long as it's all in confidence, that's not strictly putting it into the public domain, but there are risks around that things can leak out. And once they've gone and they're in the public domain, it becomes very difficult to then do anything in terms of getting a patent, because you're dealing with this strict requirement that it mustn't be public information. So normally you're thinking about patents long before you've disclosed any detail of the product to the public, and usually often before you've sort of even spoken to suppliers about potentially manufacturing parts or developing bits of your product. So it's a very difficult one to judge that. Usually it's sort of at that kind of prototype type of stage. It needs to be very carefully managed in terms of what you've disclosed at the time at which you file the application. Also, another thing to think about, which is the counter to getting your own patents, is making sure that you're free to sell a product and that it doesn't infringe other people's patents. So you may carry out a search to make sure you've got freedom to operate. And there are specific freedom to operate searches that you might carry out to establish this. And again, that's something to think about early on, because you don't want to develop your product, about to launch it, and then find out that there's a patent out there that will stop you, dead in the water, having gone through that whole development process. Trademarks, again, kind of similar. You probably want to make sure that you've got freedom to produce or use a mark. So you might carry out a clearance search to make sure that that brand hasn't been used or registered by someone else. Again, in terms of registering your own trademarks, the earlier the better is always the case. But obviously, trademarks you can leave a bit longer. There isn't that requirement for it to be sort of different to existing trademarks. So normally you would try and do that before you launch the product, so that you don't launch the product, somebody then sees it and maybe registers that mark in their own name. And that can just cause all sorts of difficulties for you. So normally you want to do the registration before you launch the product, but your clearance really wants to be before you sort of do your brand development. You don't want to go through the process of developing a whole sort of set of branding and then find that you can't use it because someone's already got a registration for that. And this first to file point is that trademarks, once registered, are assumed that the person who was the first to file the registration is the one that is entitled to the rights, and it's sort of then down to someone else to prove otherwise, so that you've got this sort of presumption of entitlement, having registered the trademark. Whereas, as I mentioned before, if it's not registered, there is kind of that need to prove that you are the genuine sort of owner of those trademarks, and someone else has come along and is utilising them and trading off the benefit of your good name. Registered designs, again, they have similar requirements to a patent, so they're judged against what's in the public domain when you file the application, but they do have the benefit of this thing called a grace period. So it means that you can disclose the product, and then you've got 1 year within which to register your design. So you can do that a little bit later, and it maybe even after launch of the product. Cost and timeframes. It's very difficult to give clear costs because it depends on so many factors and on the complexities, particularly with patents, on the complexity of the design. And also it varies depending on your geographical coverage and also whether there's any difficulties in getting the application through or not. So these numbers are very, very rough rules of thumb to give you an idea sort of what you might be sort of wanting to take on in terms of the cost. So, again, registered designs, you might be looking at something like £1,000 to £2,000 per country. Trademarks, a little bit more, probably 1,500 to 3,000, again, depending on how much discussion is required with the local patent officers. Some patent officers do more examination and assessment than others, so again, you may get more pushback in some jurisdictions. And again, patents tend to be a lot more complexity in the setting out and explaining what the invention is about. And so it tends to be a little bit more expensive. And again, some of the jurisdictions like the European Patent Office, which is a multinational organization that basically examines and grants patents, which can then be made effective in what is actually about 38 countries, I think, around Europe, and a few others like Morocco, and I think even Cambodia or something like that is now part of the process. So again, the cost tends to be a lot more if there's a lot of countries involved, but you do get a much broader coverage. And patent applications, as I've mentioned before, typically 2 to 5 years to obtain, but can last up to 20 years. And this final point about maintenance fees. So once you've got these rights in place, most jurisdictions have some kind of ongoing maintenance fee that has to be paid. With patents, it tends to be annually. Trademarks tends to be every 10 years, and registered designs tends to be every 5 years, up to the full 25 years for a registered design. The fees tend to start quite low, so I think the UK patent fee will be something like £200 for the. It actually doesn't start till the 4th year, but for those early years, going up to I think about £2,000 for the 20th year. So it's a progressive sort of increase over time. Again, it's more, I think, to get you to think about whether you still want to have the patent in place. And I sort of mentioned some of the alternatives to registration. So if you don't go down that route of registering your rights, or you haven't Sometimes it's just not applicable. You might want to apply for a patent, but the technology using isn't sufficiently distinguished over existing technology to justify getting a patent for it. But there are things that you might do in place, mostly around keeping it secret. So you may have all these clever ideas or manufacturing techniques. The key thing is how you keep it secret. And there are lots of examples of this, things like Coca-Cola's recipe or the KFC recipe, those sort of things. They've been kept secret for decades, and successfully so, but does require an extremely high level of care and paranoia around keeping those things secret. But that's a perfectly legitimate way of doing that. And the beauty of that is it does last forever as long as you can keep it confidential. So it has some advantages over things like patents, which will expire after 20 years. I often say to clients, if you can't get a patent or it's not suitable for that, sometimes just being first to market can be more important in the sense of patents. Patents are good for protecting the longevity of a product. So if you're looking at a 20-year sort of life cycle, then patents are great. If you've got a product that's only going to be sort of 2 or 3 years before it gets replaced or updated, then actually being first to market and getting ahead of your competitors can be as powerful. And so sometimes you don't need to worry about getting the IP through, because by the time the patent's granted, you've already moved on, and whilst there is that retrospective protection, they're probably not going to want to start picking that up for a product that you no longer sell. Again, unregistered trademarks, you can use trademarks if you label them with that TM. You mustn't use the R, the registered trademark logo, but you can label with TM, and that just says to the world, I'm claiming this is my trademark, this is me, and I don't want anyone else to use it, and I will sort of pursue you if you do use it. And it just gives you a little bit of an extra a step in terms of demonstrating that really this is a trademark that's associated with your company, not just some sort of name that anyone can sort of use. And also, again, for copyright, it's worth putting that little C on things where you're asserting your ownership over something. Again, it just helps if someone can try and argue and say, oh, I didn't know it was copyrighted stuff. You can say, well, there's a C on there, there's a date, and there's a name. It's much harder to then argue that there is anything other than somebody looking to protect that. So finally, just to talk about this sort of idea of a process. So this is obviously a completely artificial situation. We've got a company that's developed a product. It's the perfect toaster. It will brown your toast to perfection every time. You don't have to keep pressing the handle down. You don't have to keep adjusting it. It just works. And they've come up with some very nice technology around that. So the first thing they want to do is think about protecting that with a patent. Obviously, it's technology, it's new, it meets all those requirements, and it's got an advantage in the sense it's not obvious because you've achieved something that people couldn't achieve before. Well, I've never found a toaster that will do that. So that would be a logical place to look for seeking patent protection. And again, doing that very early is always good because of the issues around the disclosure of the idea. There's always a risk that it will leak out, and that might prohibit you getting a patent. So that should be something that's going on in a very early stage of the development of the product. So then you've got to think about your trademark, your branding. So you might give a name to your product. I've said Bronzar here. That's the name that you might associate with the product. If you can register that as a trademark, it needs to meet those requirements. It's got to be different, it's got to be distinguishing, and it's not got to be descriptive. Hopefully Bronzer is not descriptive of the toasting process, so that should be a reasonably good trademark, and you should have that registered fairly straightforwardly. Again, you might want to register the name of your company, again, because that's quite an important aspect in terms of the reputation you have and the association of your company's good name with that company name. So again, register that. And one point to bear in mind with this is people think that by registering their name with Companies House or setting up a company, they've got some kind of protection. But really, Companies House is very easygoing in terms of names. It just needs to be different to an existing company. That doesn't mean that there's not somebody out there that would be sort of concerned if you registered that name or trying to use the name that's so close to theirs that it would cause confusion. So again, simply registering the company name doesn't mean you've got any sort of rights or safety in terms of using that name. So you want to be making sure that when you choose your company name, you're fairly clear that you can use it and it's not going to be similar to someone else's, and ideally that you can register it yourself. Again, you might look at registered design for the appearance of the toaster. Now, this toaster doesn't look very particularly distinguished, but again, as long as it's got subtle differences to an existing toaster, there's no reason why you couldn't get a registered design for that. It just needs to be different, and the differences mustn't be purely functional. And most products, even quite sort of functional products, will have aesthetic elements to them. Most design engineers care about how their products look, and will have features in there that have some kind of aesthetic aspect to them, even if it's just polishing the surface or something like that. In terms of copyright, obviously things like the manual, the packaging around the product, all these things have aesthetic, two-dimensional aesthetic value, the images on the box, the writing in the manual, all those things would qualify for copyright, and that automatically comes into place. But it's worth keeping records of when that was created, and also labeling those with a little C to make sure those rights are enforced. And then you've got to consider about how you move on from that initial stage. You've now got all your sort of ducks in a row, as it were. You've got your patents, your trademarks, your designs in place, but you've got to think about how those are going to sort of pan out over time. Patents run out after 20 years. And so you want to think about how you have this ongoing process of capturing development. So you will probably develop the product and have new features, which may in themselves be worthy of patent protection. A classic example is Dyson. He came up with this sort of basic cyclone vacuum. But since that sort of initial patent, there was sort of regular cycle of developments that have gone in and patents have been covered. So by doing that, you keep adding to the sort of portfolio, and your patent expires. The first patent expires after 20 years, but your second patent has got another 5 years to run, and the third patent has another 5 years to run, and you can kind of maintain a coverage of all those developed products over time. So it's worth continuing to have that process of monitoring your IP. And then finally, you want to review what IP you've got and say, well, do I still need to have this? If you've got a patent that covers something in a product that you've stopped using, there's no point in paying to have that patent in place. So you might want to say, well, I'm just going to drop it, not continue to pay for it. Or you might even think about selling it or licensing it to someone else to use and get a revenue stream from that as well. And this all comes back into this sort of general idea of managing and using IP. It's important to have this ongoing monitoring, to both look at what you've done to see, have you come up with new ideas? So whilst you're solving problems, it's worth noting those down, and looking at the solutions you've produced, and then saying, is this worthy of protection? Is this something that a competitor might want to use that I can then stop them using? And it's worth having those sort of regular, just stop and take stock of what you've done and saying, actually, let's think about this. What have we done in the last 3 months, 6 months, 1 year, whatever it might be? Have we developed new technology? Have we got new brands that we're using? Have we got aesthetic creations that we might want to think about registering? And just sort of go through that process and say, let's have a think about it, and let's take steps if necessary. It may be there's nothing there to do. We just carry on and go on from there. And then again, this is this sort of regular review of IP. There's no point having the IP if you don't do anything with it. So if your competitors are brazenly using your IP, either your technology or your brands, there's no point if you don't enforce that. So you need to have be cognizant of what's going on in the world around you and seeing what your competitors are doing to see if that might be sort of impinging on your IP. But also, as I sort of said before, are you still using that IP? Is it worth continuing to pay for it and keep it maintained? And questioning whether the value you're getting out of it really justifies that annual expenditure. And as I said, you could be paying £2,000 a year for a patent towards the end of its life. Are you actually really getting £2,000 of value out of it? So again, it's worth having that assessment on a periodic basis. I mean, this is kind of more further down the line when you might have quite a developed portfolio of IP, but still something that needs to be done, because you can end up spending a lot of money on IP protection to maintain it that you might not need. And also, as I sort of again mentioned before, you might think about other revenue streams. Even if you're not using IP, is it worth trying to license it, sell it, franchise it, whatever it might be, to get some value out of it that you're not necessarily using yourself? So really, just to sum up, in terms of IP, obviously the first thing you do when you're starting out is you need to make sure that the field is clear for you to develop your technology. Don't develop technology that's going to be stumped by some existing patent or protection that's in place. And in terms of branding, you need to make sure that you produce brands and develop brands that aren't going to be falling foul of somebody else's rights. So you need to start that sort of field clearing process. That obviously wants to be done sooner rather than later, because you don't want to develop and invest a lot of time and effort in something that you're going to get stopped from utilising, later on. You need to manage and control your IP. So one of the important things here is ownership. If you're using contractors to develop IP, you need to make sure you're clear about who owns that, because what you don't want is to find 5 years down the line that you file for a patent application, or you want to file for a patent application, or you have filed for a patent application, and it turns out that you weren't the owner because you didn't create the IP in the first place. So if you're doing contractor agreements, make sure ownership is clear. Even if it's going to the contractor, you need to be clear about that so that you know what the position is. In terms of the unregistered stuff, it's important to record it and make sure you've got clear records of when stuff was created and properly labelled up, so that you can evidence that if should you need to in a court situation. And it's important to audit your IP, as I say, having those regular sort of reviews of when and what you've got to see how you might sort of take steps either now but also in the future and ongoing. And assess your part of this should be assessing your protection requirements. So look for patents. Make sure you do those before any disclosure of those ideas. Make sure you apply for trademarks before you launch them, so that nobody else can sort of sneak in and try and get ahead of you. And the same with registered designs. Make sure you do those within that grace period if you have already disclosed them, but ideally sooner rather than later. And finally, that's that sort of point about reviewing and monitoring. Make sure you've identified anything that's new that might be worthy of new protection. Keep an eye on your competitors and make sure you're actively utilising those rights you've got and paying for. So that's really everything there. I guess now, if there's any questions, we can sort of address those. And if you have any questions at all now or afterwards, please feel free to